the deceased cohabited with the plaintiff as husband and wife, and that is within the knowledge of the deceased mother, the deceased brother, the deceased sister, and DW5, who is all plaintiff witnesses and possibly other members of the society knew received the said animals. His wife may not have known whether they were part of dowry or what. She clearly stated she was not part of the negotiations, and she was also not part of the dowry payment, as expected with the luhya customs, that ladies or women are not involved. She stated it was for the children, but I refuse and decline that part of evidence. It is clear that the defense witnesses knows that dowry was paid, partly paid by the plaintiff. I'm not convinced by the deceased mother's evidence and any other defense witness that the animals was not part of dowry. Women were not involved, and anyone who came forth to say dowry was not paid, being a woman, cannot therefore be taken to have told the truth. The possibility is that she did not know anything about dowry payment, and all she does not mean they divorced as husband and wife. The first issue. The other issue for determination is whether the deceased left any wish interred elsewhere than the plaintiff's home. According to her son, said to have been close to her brother, the defendant. The defendant, then the plaintiff proved the existence of marriage between himself and the deceased. A marriage that had not been dissolved legally, either customarily or through the court process. Then I find the plaintiff is the one who is closest to the deceased in legal terms, because he proved that closeness, and he proved the color of right to bury the body of the deceased, which is Nyongesa. He was the husband of the late, irrespective of their indifferences and irrespective of their separation. They were in touch, and that is evidenced by the plaintiff's attendance to the father's burial, which evidence was confirmed by his son, and also by the plaintiff's visitation to the deceased in hospital when she was sick. A question emerged during cross-examination of the defendant, and he confirmed he also visited the deceased twice. And counsel for the plaintiff was of the view that if you visited the plaintiff twice, the deceased twice in hospital, and the plaintiff visited twice, then the plaintiff also recognized the deceased as his wife.
Okay, my name is Mandala, an advocate of the High Court of Kenya. Today's case was basically a dispute with regard to customary marriage and the right to bury a deceased spouse. What the court has decided today is that as a husband who had paid dowry, he has a right to bury the deceased spouse, whether they were living together or separated, that notwithstanding. Further, the court has directed that there will be a ruling later on today to confirm the issue of whether there will be a stay before appeal, because the deceased family intend to appeal against the ruling by the senior resident magistrate. He died in mid-March, 15th March. So immediately the plaintiff moved to court, and it has been determined today.
Maybe what was their argument?
What was the argument? The argument by the plaintiff was that he had been denied even a right to view the deceased in the mortuary. He could even not access. So the court initially gave him the orders to view the deceased as the husband and access the body anytime unconditionally. That is why we approached the court demanding the right to bury the deceased spouse.
The
yes.
two lived for how long?
They lived for close to 10 years. Then there were some minor disagreements. However, there was no formal separation. They had 5 children out of the marriage who are now adults. And incidentally, the children were opposing the father's right to bury his wife, and the court has disagreed with them.
What does that mean?
Unatoka Tarasa. Okay. Yaani unatokea Malindi unaingia Tarasa kwanza. Mimi nimetoka Tarasa. So I retired from public works. I was working just as boss.
Oh.
She's your sister?
That is my sister. It's also very familiar.
We have worked.